Welcome to the Ottawa Business Journal's live broadcast of Navigating Ontario's Employment Standards Act and Recruitment. I'm Michael Curran from the Ottawa Business Journal. Thanks for joining us today in such great numbers. We've got hundreds of people registered. We're live on YouTube, live on LinkedIn. Since 2021, the Government of Ontario has passed several iterations of the Working for Workers legislation. Each of these has amended important employment-related statutes such as the Employment Standards Act and the Occupational Health and Safety Act. Notably, and what we're talking about here today, are new legal requirements under the ESA in respect to the recruitment process. We're going to tell you what that means in a second. With these new requirements set to come in effect in January 1st, so this is very timely, it's crucial that employers act proactively in coming weeks and months to ensure that they properly understand the scope of the new statutory obligations and adequately prepare for compliance. Here are a few things that we're going to cover today. The scope of the new requirements, which touch on things like publicly advertised job postings, areas of potential concern or ambiguity for employers, touch on that in topic 2, and practical tips and suggested steps to ensure you're compliant before January 1st. When we are discussing these employment law issues as these ones, we turn to our experts at Eamon Harnden LLP. Of course, Eamon Harnden is locally headquarters, founded in 1987, home to the largest group of lawyers specializing in labor and employment law in the National Capital Region and other cities. Our guest today has expertise in all facets of labor and employment law, working with clients across both the public and private sectors, from representing employers in labor arbitration cases to defending their interest in civil litigation and human rights matters. He is a trusted ally resolving legal challenges in an effective and efficient way. Please welcome from Eamon Harnden LLP, here is Jake Tolton. Hey, Jake.
Hi, Michael. Thanks for having me.
I should say welcome back, Jake, because you were actually with us about 2 years ago. So back by popular demand, we'll say, Jake.
I'm glad to be here. I think that a couple of my colleagues have been on here recently to talk about this piece of legislation that we're discussing today, the Working for Workers Act, which has had a number of iterations over the years. There was the often discussed disconnecting from work policy that came in a couple of years ago. There were some statutory requirements with respect to non-competition agreements. There was the licensing for temporary help agencies. And now we're actually under the 4th and 5th versions of this piece of legislation that have some important requirements for employers to be aware of when it comes to the recruitment process.
Yeah, and what we're talking about here, Jake, is, as I indicated already, coming into effect on January 1st. And just a note for all of our viewers, those previously recorded podcasts are on OBJ's YouTube page. You can check them out. It has been a little bit of an evolving process. And as you said, Working for Workers number 4. It sounds like a blockbuster here, like a Hollywood blockbuster. They just keep doing the follow-up ones, and there's new stuff every time, right?
Yeah.
Jake?
And I mean, as we know, the recruitment process can be fraught with challenges, and so by taking proactive steps to prepare for these incoming changes, employers can avoid creating unnecessary headaches for themselves in the new year and sort of effectively mitigate any risk associated with the recruitment process moving forward.
Yeah, I think we're about to share some information that isn't broadly known, and I think that's what's interesting. It's timely, it's new information. So as usual, we've divided today's show into 3 different topics. In topic number 1, we're going to look at the scope of those statutory requirements. Number 2, we dive into areas of concern, a little bit of ambiguity potentially. In number 3, how you can prepare for compliance. What Jake's suggestions are for next steps. And then, as we often do, sometime around 12:25 for the live audience on YouTube and LinkedIn, we'll be taking your questions. You don't have to wait, by the way. I just want to underline that fact till 12:25 to ask them. You can ask them as Jake is presenting, and we'll start sifting through them throughout the live broadcast. All right, Jake. So topic number one, let's give people, put some meat on the bone, as they say. Let's take a look at the scope of these new statutory requirements. Here's topic number one.
Thanks, Michael. So first and foremost, provincially regulated employers should take a close look at the new legal requirements, which touch specifically on publicly advertised job postings, post-interview communication with interviewees, and record retention to ensure that they understand the scope of this new legislation. It's important to understand that these statutory requirements will be backed by ministry enforcement, so compliance is not optional. The first one that I'd like to touch on is the new requirements around job postings. So effective January 1st, 2026, these requirements impose an obligation on certain employers to include key information in certain job postings. And what the stated goal of this new piece of legislation is to make the compensation more transparent during the hiring process and more equitable for job seekers. So let's start with the application. These new rules are going to, with respect to job postings, are going to apply to employers with 25 or more employees as of the date of the posting, and they're going to apply to publicly advertised job postings and the related application forms. So these are going to apply to job postings that are on LinkedIn or Indeed or other websites. They don't apply to internal postings for existing employees. There are several important requirements that employers should consider. The first is that there is a requirement for salary transparency about expected compensation or the range of compensation. So where a publicly advertised job posting references a range of expected compensation, the range cannot exceed $50,000 unless the total compensation surpasses $200,000. So, for example, a job posting that included a range of compensation from $80,000 to $135,000, which is a $55,000 range, would run afoul of this new requirement. Some of the employers might be wondering, well, what does compensation include? So, in the context of these new requirements, compensation means wages, which is salary, bonuses, commissions, and any other forms of non-discretionary remuneration. So anything that falls under those sort of categories has to be considered in that salary range. Another very important new disclosure requirement for employers and these job postings is going to be to disclose the use of AI when it's used to screen or assess select applicants for the position. There's also going to be a requirement for proactive disclosure whether a posting is made for a genuine existing vacancy or whether it's just being created so that the employer can establish a pool of qualified candidates. Lastly, there's a prohibition with respect to job postings on a requirement for quote unquote Canadian experience. And so employers will not be allowed to specifically require Canadian experience in their job postings. I think we should dive in perhaps a little bit more into what constitutes a publicly advertised job postings. So it would be things like a general recruitment campaign for a specific position, something that's posted on LinkedIn, something that's posted on Indeed. It's not for internal for openings. And so employers need to be aware that these requirements may only come into effect if they decide to recruit outside the organization. Another new requirement under this act has to do with post-interview communications. And so what the new legislation is requiring is that once an applicant has been interviewed for a publicly advertised position, Employers will, as of the new year, be required to inform the candidate as to whether they have made a hiring decision within 45 days of the individual's interview. And this communication can be made via email or in person or via a Zoom call, but they do have to advise anyone who's interviewed for the position what the results of the interview process were. And the stated intention behind this new requirement is to prevent the issue of hiring managers, quote unquote, ghosting prospective employees who've invested time and other resources into the recruitment process. The last new requirement that I want to touch on quickly has to do with record retention. So starting January 1st, 2026, employers will be required to retain every publicly advertised job posting and all related application forms, plus records of any information provided to candidates. And this record retention requirement is going to be in effect for 3 years after the posting is initially put online or provided to the public. So at the end of the day, we have these 3 new requirements with respect to the salary range, the use of AI, and the contacting of interviewees. And what we're seeing here is not really just a compliance checklist, but we're seeing almost like a significant cultural shift towards transparency, algorithmic accountability, and what the government is sort of justifying this is equity for historically marginalized groups.
Really interesting stuff, Jake. By the way, the questions are coming in about all sorts of stuff. But not that you and I get a vote in this legislation that's been passed as being enacted. It is a big change, right? And I could see how lots of HR managers, business owners, business managers, would have some concerns about this range of compensation. I picked up on the fact that you said it's a $50,000 or less than a $50,000 range, but even there would be some sensitivity, right, for businesses or public entities in like making their salary ranges public. I mean, particularly, I guess, if it's a private sector business, right, Jake? Like, so that's a little dicey. I get the flip side of it, which is you don't want people applying for a job if they have no sense of what the compensation is.
Absolutely. And I think there are certain sectors that are going to have to be more sensitive to this than others. The first one that comes to mind is possibly tech, where you have tech sales and roles with just a really wide range of overall comp. And I think that there are going to be some pitfalls there in that sector that employers are going to have to be wary of.
Yeah, I'm sure the other thing that is provoking, and this isn't legal, I'm not looking for a legal opinion on this. This is just you and I and everyone else, I think, trying to get on some of this stuff. I think the prohibition on requirement for Canadian experience. I mean, all of us want to have a lot of equity out there and all that type of stuff. But there are, in my understanding, I mean, government jobs, for example, where, you must be a Canadian citizen to work in certain pieces like that. So anyway, I guess all of this, as all employment law is, people will need to contact experts like you, Jake, your colleagues at Eamon Harnden, to sift through some of this stuff, because I think some of it looks good on paper, but it needs a little bit of interpretation.
Absolutely. And employers still need to be able to post job postings that accurately describe the requirements of the position. And myself or any of my colleagues are obviously available to help navigate that process and make sure that employers are still compliant and also finding the candidates that they want.
Yeah. But I picked up on what you said, right? Really, this is a step towards transparency, which I think all of us are in favor of. Like, let's just take the AI screening one. From what I hear about local business owners, they're sometimes, you make a job public, let's say on LinkedIn or Indeed, and the challenge these days is you are literally flooded with hundreds of applications that, actually almost slows down the process. So I can see, given the ease at which people can apply for jobs at the click of a button, that employers will need to use AI. But then, as we all know, you need to be aware of the AI algorithms, and is there a sense of anything discriminatory in the algorithm or that type of stuff. So I think it's noble and worthwhile to address these. Just a little bit of complexity around, what actions you actually take, right?
Yeah, and I think that in this next section, I'm going to dive into a few areas of concern or
Yeah.
ambiguity that I want employers to be aware of as they try and navigate these new requirements.
Yeah, perfect segue, in fact. And I almost don't have to say it because of the number of questions coming in, but just a reminder, we will get to your questions around 12:25. All right, so let's go to topic number 2, which is, as we said, we've kind of set it up here, areas of concern or ambiguity. Take it away, Jake.
Great. Thanks, Michael. So the first sort of area of concern that I want to chat about is where employers have standard or template job postings that they use. And there's obviously now a concern that these standard templates may not comply with the new rules if they don't provide the salary transparency or if they don't follow the disclosure of the use of AI. And so employers need to be very careful about recycling these template job postings starting in January 2026 if they haven't made sure that they're meeting these new requirements. The other thing is that some employers may not have a practice of contacting every single candidate in a timely fashion, or sometimes even at all, following the conclusion of the interview process. So that's something that they'll need to be aware of. Another thing is the record keeping, and this is probably going to be the most sort of burdensome aspect of the new legislation, especially for smaller organizations, because we're talking about, retaining records and sometimes a significant volume of records for a 3-year period. And that's going to require someone to be in charge of that mandate, to organize those records, to file them. Some employers may need to purchase new software in order to sort of keep everything organized. So those are sort of, at first instance, the main concerns that I think that some employers will face with this new legislation.
Yeah, for sure. And I think that, as we indicated, there's some merit to this, right? We don't want people that have spent hours applying for a job to be ghosted, right? Like this makes a lot of sense. But as I keep referring to the questions, Jake, there's a lot of really specific questions that people are asking about. So it does seem like it's just in the interpretation of what this means in a practical sense. So why don't we go directly, since we're going to be in the Q&A for a little bit of time here in a few minutes, Jake. So we'll keep on trucking, as they say, and we'll move to topic number 3, which is the really practical aspect of today's show, how you can prepare for compliance, suggested next steps. So let's tackle that, Jake, and then we'll get to our questions.
Sure. And so I think that employers can sort of create a little bit of a checklist for themselves for the new year. The first thing is to look at all their standard or template job postings and discuss whether they include a salary range. If they don't, and the expected salary is under $200,000, to contemplate what range they're going to include in that posting. They need to look at what tools they're using to assess these applications. Are any of those tools artificial intelligence? And if so, that also will need to be disclosed. Another practice that some employers, especially sort of larger employers, need to be aware of is where they have sort of an ongoing job posting to create a pool of candidates. That needs to now be clearly identified, and they need to make sure that they're not making these postings without clearly stating that there may not be a specific vacancy at that time for a position. And then the last thing is obviously with respect to the issue that we just discussed and the record keeping. whose role within the organization is that going to be? Making sure that that person is up to date on the legislation and exactly what they need to be keeping track of moving forward so that they're on side of their obligations with respect to record keeping.
All right. We're making good time, Jake, and it's good that we have a few extra minutes for our questions. So before we get into any of this, I think we should just underline, Jake, that anything that you're answering here does not constitute official legal advice, and that I'm saying this, of course, for your sake, because we're going to put you on the hot seat here, Jake. And there's a context to every question, right? Is this a union shop? Is it public, private business? Is it large? Is it small? And all that type of stuff. So Jake will try to answer some of these questions. And if you just need more context and want to pass, Jake, just let me know.
Sure. I'll just say that, I'm happy to sort of speak in broad generalities about this new legislation. The other thing is it hasn't come into effect yet and it hasn't been enforced. And so there are some cases where we're just not sure exactly how the Ministry of Labor is going to approach these situations. We can sort of safely assume it'll be contextual and on a case-by-case basis.
So that's really important too, to emphasize. There might be more details from the Ontario government on that further define some of this type of stuff. So we'll work through some of these, Jake. I'll put them on screen here. And again, if you want to pass, just let us know you want to pass. So the first question, I think it's from Eric. Do we know yet what they define as the use of AI? To my mind, that's pretty clear, but any comment on that? We all have AI built into if you're a Microsoft user, you got Copilot, we use Gemini Pro, but what do you think AI means?
Well, I mean, there are very obvious cases of AI, right? ChatGPT, but it's helpful because the regulation actually defines artificial intelligence for us.
Okay.
And it defines it as a machine-based system that for explicit or implicit objectives infers from the input it receives in order to generate outputs such as predictions, content, recommendations, or decisions that can influence physical or virtual environments. Okay. Now, I recognize that's a fairly wordy and perhaps not super helpful at first instance, but any program that is taking a threshold analysis of resumes as they come in, I think we can safely assume would fall under the umbrella of AI.
I think that's very fair, right? If you're using AI or any automated digital system to sort through or rank applications, I think that's what we're talking about here. Doug Spencer has a question. So earlier, I think you said the 45 days. That was in regards to post-interview communication. So I guess Doug is asking, is that 45 calendar days or is that 45 working days or we don't know?
It'll be 45 calendar days.
Okay, there you go. Sometimes there are easy answers. Okay, here we get the next one here. So let me read this out for you. We inform the candidate that we're not proceeding. Does this mean a second communication to inform them that we've hired? Oh, interesting. So let's say it's a multi-phase process and the person's gone through phase one and the organization says, yep, sorry, not, do they inform them there and inform them when it's been filled or not certain, Jake?
That's actually a great question. So my reading of the new requirements is that after there's been an interview, you only need to inform them once about whether that candidate is proceeding or not. You don't need to tell them what the final result was or who was hired or anything to that effect. You just need to let them know within 45 days whether, is there going to be another interview or we're not proceeding or if the position has been filled. There's no requirement as it currently stands for a second follow-up at the ultimate conclusion, let's say, of the recruitment process.
So it's really just update them as to what stage they're in. Okay. I presume based on the email, this is from Beverly. And I asked you this question, Jake, in the prep for this call. And I said, what if I have a coffee with someone? And Beverly's asking, in topic of interviews, if I say to someone, hey, can you give me a call and we'll just chat about this? Is that an interview, or is that something that would be categorized as pre-interview or something?
I think that, and as a sort of employment lawyer, I always lean to the side of caution. If you're sitting down with someone face to face and discussing their interest in the role and the details of the role, then that would likely be considered an interview. And I think that you would want to abide by these requirements.
Sounds like safe advice to me.
What I wouldn't consider an interview was sort of, an initial email inquiry from someone saying, hey, I'm curious about this job. Can you tell me a bit about it? That I think we can sort of safely say it would not fall under the applicable definition. But any sort of meetings, face-to-face, one-on-one, where there's a rhetoric
video
about
call, phone call.
The position, I think would trigger the requirements.
All right. This one's really specific, but we'll see if you have any advice and if you don't. If we ask for a business development manager to have a strong understanding of the defense sector and processes in Canada, would that be illegal under the Canadian experience requirement? And of course, what we're saying here is the job posting. But anyway, do you have a sense on this one?
So I won't answer that sort of specific set of facts. What I will say is I think that employers can still be deliberate about the requirements of the position. I just can't, I don't think that they can specifically use the terms Canadian experience. But rather, if you want to say, for example, if you're looking for someone who has knowledge of the Employment Standards Act or knowledge of the Occupational Health and Safety Act, that is a completely fine requirement to stipulate. And even though that may be, Canadian experience, as long as you sort of specifically identify what you're looking for, I think that it's okay.
I think it's fair too. Listen, we got another related question on that one. I think you might have a simpler answer to this one. Does Canadian experience transparency required for companies with fewer than 25 employees?
So I think that Canadian experience requirement is across the board.
Okay.
That is not specific, and perhaps I can just clarify the salary range is specific to the 25 or less. But I think that all employers would be wise to avoid using the specific Canadian experience terminology and job posting.
And again, that seems just the wise advice, like just stay away from saying Canadian experience required.
Yes.
I don't think we've ever been more into the weeds in some of these stuff, and it just shows you the level of interest in this, Jake. So again, I presume this is Zach Fleming based on the email. The presenter indicated earlier the 50K span doesn't apply above 200K. My understanding is that jobs above 200K are not subject to disclosure at all. So the 50K span is moot. Any help for Zach?
That is correct.
Okay.
That is correct. Now it's a bit of a catch-22 for employers, right? Because if you're not including that salary range, and you have more than 25 employees, you have to sort of think about what the expectations are going to be in the mind of the applicant when they put in their resume and they put in their cover letter, because they may be aware of the fact that if it's not disclosed, then the salary is above 200,000. Okay.
Wow, some really specific ones here. Our organization focuses on Canadian research and innovation. How do we navigate the prohibition of mentioning requirements for Canadian knowledge and or expertise? Any advice on that one, Jake?
I think you have to craft the wording of the post accordingly, and I won't get into sort of the specifics of that, but you guys feel free to reach out to me if you want to sort of discuss these very specific situations or job postings.
And don't worry, we're not going to continue for 10 more minutes on this, Jake. I think we got a couple more, and then we'll move on to our takeaways. And I think this one, hey, I've got some advice on this one. How do we stay updated for additional details and context that may come from this? We will be sharing your email address, Jake. So I'm sure if someone sent you an email and or visited Eamon Harnden website, I presume you guys have some newsletters that people can sign up for?
Yes, there are. If you visit our website, there are a number of resources you can access, or you can reach out to any of our lawyers directly.
Okay, great. And we'll be sharing that contact information in just a second. And the final one I think we'll throw at you, Jake. You've been a good to get through all of these. Does this mean we need to disclose something like knockout questions that LinkedIn provides? I consider that to be AI, and to be honest, I don't know. Sorry, Eric, what a knockout question is. Maybe you know, Jake.
So I think that refers to a screen out question where where if the candidate doesn't meet that specific requirement, their resume is just eliminated. I would say that yes, that would have to be disclosed.
Okay. And sorry, I'll sneak one more in because this one's real. I think that's a really interesting question. So regarding the salary range of job postings, any guidance on range, like starting from the midpoint and then going below and above, or go below? Do you have any thoughts on that, Jake?
I'm not sure yet.
Okay.
I because we haven't seen these requirements in yet. I haven't had to sort of experience any of these specific challenges yet. So I don't have any advice on that at this time.
Okay. Yeah. Well, listen. Thanks again, Jake. It's not easy sitting there having no sense of what people are going to ask and understanding that by definition, employment law is complex and depends on context and all that type of stuff. But why don't we shift to our key takeaways here, and then we'll share your contact information. Tell us more about these, Jake.
Sure. So I really just want to encourage employers to be proactive here. Review your job postings. Start to put together a plan for record retention. Have internal discussions about the use of AI, whether you're using it or not, or whether you might plan to use it in the future. Review any internal policies you have with respect to the interview process and following up with candidates. And of course, if you have any questions, visit our website or reach out to me directly, and I'm happy to provide more detailed advice on any of the issues that we've discussed today.
Yeah, perfect. I think that's great advice too. There, as we discussed, topic number 2 is all about the ambiguity. There's some ambiguity, but there's some clear next steps that people can be taking in terms of disclosing AI, salary ranges, changing your template, so on and so forth. Let's bring that contact information up on screen. And there you go. You can call Jake at 819-230-0580 if my eyes don't fail me. And it's Jake Tolton at ehlaw.ca. And of course, ehlaw.ca is the website that you can visit. I'd encourage all of you to reach out to Jake, visit the website, sign up for their newsletters, because I'm sure this probably isn't the end of the legislation. Or is it, Jake? Like, is this coming to the end, or is working for workers going to continue?
No, there is already some tabled legislation for another version of these requirements. Wow. So perhaps I'll be back here in the near future, Michael, with some more information for everybody.
That sounds like a fair bet. All right, Jake, listen, you've been a great source of expertise and advice. We want to thank you for spending all of this time with us. Thanks, Jake. We really do appreciate it.
Thank you.
All right. Just as we wrap up, a reminder that you can visit obj.ca website every day for the latest in local business news. I highly recommend you subscribe to OBJ Today, our weekday email newsletter sent Monday to Friday around 4 p.m. I know you're probably thinking, why do I need another email in my inbox? I promise you, there are thousands of local business leaders subscribed to this, and it gives you a really nice, tight summary of what's happening in local news, help you make better business decisions. And of course, if you want information, you click through to the website. If you're following us on social media, please, especially LinkedIn, by the way, I think we've just eclipsed 42,000 followers. Please follow us there. And if you're on YouTube right now, you can click the red subscribe button and then the little bell icon. And if you do that, every time we go live or post a new video, you will be informed. I want to thank all of you for trying to stay abreast to all of these employment law changes. Please stay tuned for more podcasts. In fact, we have one coming up in early December. So keep an eye out for that one. I want to thank Jake Tolton and our friends at Eamon for working with us on this. Have a great day. Hope to see you real soon. Bye-bye, everyone.